An overview of types of companies and a brief comparison between public company and private company. Main classification of companies is always on the basis of liability of members. If there is unlimited liability, it is an unlimited company. If the liability has got a limit, then it is a limited company. Limited company has two variants: limited by guarantee, where an amount is guaranteed to be paid on winding up. In respect of limited by shares, the liability is restricted to the unpaid value of shares held by a member. I am Vittal Prabhu, bringing you the weekly video on business law refresher. Hope you will find the video interesting and useful. Companies limited by shares can take the form of a private company, which, as defined in the Act, should have a minimum capital of rupees 1 lakh and have 3 restrictions in its articles on transfer of shares, number of members, and invitation to public for subscription. Companies Act uses the same definition to define public company in a different way. It states public company means a company which is not a private. A public company can get its shares listed on a recognized stock exchange, and it can be called a listed company. When the shares are not listed, the public company stays unlisted. A company may operate in India, but it might have been incorporated outside the country. Such a company is called foreign company, and its Indian counterpart is known as domestic company. Some companies come into being by way of a legislation passed in the legislature or in the parliament, and they are known as statutory companies. There are companies where 51% or more of the shares are held by either central government or state government or a combination of them or any company floated by them. Such company is called a government company. In a company limited by share, board of directors might be controlled by another company, or 51% of the voting power might be held by another company. In such a case, the company is known as a subsidiary company. In a company where the control is less than 50% but more than 20% of the voting power, it is a case of significant influence exerted, and such companies are known as associate companies. In both cases, the company which holds the control is known as a holding company. Private companies help small businesses by providing for a concept of small company where there is a restriction of maximum capital of 50 lakhs and maximum turnover of 2 crores. This is to help businesses prosper by taking governmental facilities. One more company form which is used mainly by SMEs is a special form of company known as one-person company, where an individual can form a legal entity for promotion of business by following certain restrictions, and one-person company is widely used by the technocrats. We have got one more form of company which is formed for the sake of promotion of objects such as charity, art, commerce, science, education, environment, religion. It can be formed by individuals, firms, companies, or a combination of them, but the restriction is they have to pay no dividend to any of their members, and all their funds are to be used exclusively on the objects. Now, this is the way a company limited by shares takes shape and acquires so many features for the success of businesses. Understanding the two companies by elements is quite helpful. A public company needs 7 members minimum, private only 2, maximum no restriction in public but limit is 200 in private. Directors at least 3 required in public, 2 will do, could be recruited by single resolution, no retirement by rotation in private. On appointment of directors, consent to be filed with ROC in 30 days and qualification shares apply for promoters. No requirement of filing in respect of private. Invitation to shares to the public, a public company can do, private company is prohibited. Transferability of shares, free transferability in public, restriction permitted in private. Quorum depending on the total number of members for a members meeting. In case of private, 2 members form quorum. Managerial remuneration not to exceed 11% of profits in public, no such restriction in private. Commencement of business after minimum subscription, but in case of private, immediately on incorporation, business could be started. Minimum paid up capital required for public is rupees 5 lakhs or higher. In case of private, it is rupees 1 lakh or higher. For the issue of capital to existing members only as per section 62, but the section allows private company freedom. Disclosure of interest is strict, not to participate or vote applies to interested director. No such restriction in a private company. Both public and private have their own relative strengths in respect of the 12 parameters, and because of these distinctions, businesses make use of them depending on their specific requirements.